The future of higher education in our country could be forever changed as the Supreme Court prepares to take up two cases involving the always hot-button topic of affirmative action.
The justices are being asked to strike down affirmative action in lawsuits which accuse Harvard and the University of North Carolina of discriminatory admission policies. Newsy national correspondent Haley Bull is live outside the Supreme Court with more on these cases and, of course, the potential impact on higher education as a whole. Hey, Haley, good morning.
Hey, good morning. These cases on affirmative action have the potential to impact decades of precedent and admission processes in colleges across the country. Now, a little background. The court has previously allowed schools to consider race among a number of factors to advance the educational benefits of having a more diverse student body in a narrowly tailored way. Now, today, the court is going to hear two different challenges, two different cases, both brought by a conservative activist-led group, Students for Fair Admission. Now, it's against the nation's oldest private and public universities, Harvard and the University of North Carolina. Now, this organization has been unsuccessful in the lower courts, but today will make their argument in front of a court that has seen three new justices appointed under Trump, and that recently overturned Roe v. Wade and the Dobbs decision, which is something the petitioners have pointed to in these cases. Now, the cases ask specifically if the court should overturn a case called Grutter. It goes back to 2003. It is a case that upheld the University of Michigan's consideration of race in a narrowly tailored way, again, as we mentioned, for the use of educational benefits and having a diverse student body. Now, in the case involving UNC, the case is brought under the Equal Protection Clause of the 14th Amendment. Now, the organization argues that the policies disadvantage white and Asian American students. One question specific to this case is on race-neutral alternatives. The organization says UNC has them and that explicit racial preferences are not constitutional. Meanwhile, UNC says it needs race-conscientious admissions to achieve diversity, pointing back to its history of excluding black students and the impact that continues to have today on diversity. It notes that race, though, is only one of more than 40 factors considered. Now, when we look at the case specifically against Harvard, it's brought under Title VI of the Civil Rights Act. Now, the organization here argues discrimination specifically against Asian American students. Now, the court will consider if Harvard has violated the Civil Rights Act through alleged racial balancing and overemphasizing race. Harvard says it looks at many factors under someone's individual uniqueness and that race only benefits students who are otherwise already highly qualified. The school also says that it has looked at alternatives and has not found one that would achieve the same educational benefits. Listen to what one legal expert we spoke with had to say when explaining how this breaks down.
So the way universities defend using race is they say we need diverse student bodies, having different perspectives, different voices, different experiences come to bear in the classroom and on campus. That's good for everyone. If you're a college student, it's good for you to be exposed to people from different backgrounds. And we need to use race to have diversity in our student body. So that is the actual justification that both Harvard, UNC, and every other university is using.
Now, there are already 9 states that began affirmative action through ballot initiatives. That includes in California, where the University of California has weighed in a brief to the court, saying that despite their efforts to look at other approaches to promote diversity, that the school still struggles to enroll what they call a sufficiently diverse student body. The College Board also wrote in supporting the schools, saying that the petitioner's request would put the admissions process across the country into upheaval. The Biden administration also supporting the schools here in this case. Now, initially, interestingly, both of these cases were consolidated, but then later separated back out. And one thing to note is Justice Ketanji Brown Jackson previously served on the Harvard Board of Overseers and is a graduate of that school, so has stepped back from that case. We expect arguments here to get underway around 10 a.m., but not a decision until the court terms end. So you're looking at later in the spring, Rob.
All right, Haley Bull reporting live from the Supreme Court. Another momentous decision in the works here getting started today. Haley, thanks so much.